Aside from the enforcement and compliance process, our WCOs must also have a basic understanding of how WESM-related disputes are resolved. So our topic of interest today is all about the dispute resolution process in the WESM. Consistent with the self-governing structure of the WESM, Clause 7.3 of the WESM rules prescribed that disputes among and between the market operator, the system operator, the WESM members, or in certain cases, intending WESM members and applicants for registration as WESM members, be resolved through modes or processes that are conducive to, and are spontaneously and/or efficiently enforceable, within the market framework. The WESM dispute resolution process shall be consistent with the EPIRA Law and Republic Act No. 9285, otherwise known as the Alternative Dispute Resolution Act of 2004. The policy governing the WESM dispute resolution process is prescribed under Clause 7.3 of the WESM rules. As to the applicability, the scope of authority is delineated or harmonized with that of the Energy Regulatory Commission in the PEMC-ERC Protocol. Meanwhile, the WESM Dispute Resolution Market Manual contains the requirements and the procedures for the resolution of WESM-related disputes. Lastly, the disputes cognizable under this process is enumerated in Clause 7.3.1.1 of the WESM rules. The disputes cognizable under the WESM dispute resolution process are the following. Disputes that are being resolved in this process refer to the disputes or claims among the WESM members arising from or connected with a WESM transaction, with their legal relationship being defined by the WESM rules, the various market manuals, bilateral contracts, if there are any, and other related rules under the EPIRA. Meanwhile, the following are not within the coverage of a WESM dispute, but are under the jurisdiction of the Energy Regulatory Commission. An arbitrable WESM dispute includes inter-parties cases, and excludes cases involving violations of regulatory policies. Here's an illustration of the dual aspects of the WESM rules. Let us examine the advantages of arbitration over regulatory adjudication. Aside from being the global trend, with promise of stability or maturity norm for a free, self-governing market, the agreement-based arbitration satisfies a list of WESM objectives. For one, agreement-based arbitration is cost-effective. Voluntary arbitrators are ready to be tapped from private ADR providers. On the other hand, the regulatory adjudication is governed by the ERC, which now leads to the question, would ERC deputize private practitioners as its hearing officers or adjudicators? The agreement-based arbitration process is efficient. The final award made by the arbitral tribunal shall be binding on the parties and is enforceable. Whereas, in the regulatory adjudication, the ERC has to necessarily review, for it to issue a binding decision, unless all the parties unanimously accept. The agreement-based arbitration encourages party autonomy and support a level playing field since it is facilitated among the participants. Here are illustrations on the comparison between arbitration and regulatory adjudication. The Dispute Resolution Market Manual adopts the latest arbitration rules by the United Nations Commission on International Trade Law and the International Chamber of Commerce, or ICC, including the latter's emergency arbitration rules for urgent matters. The DRM manual will next seek to adopt the US-based International Center for Dispute Resolution's Final Offer Arbitration, or Pendulum Arbitration, for resolution of disputes in the retail competition and open access or retail market. In addition, The DRM manual will also be seeking to adopt the protocols for virtual hearing by the UK-based Chartered Institute of Arbitrators. The Dispute Management Protocol, or DMP, is a system that enables the parties to negotiate between and/or among themselves before referring the matter for mediation. The DMP focal persons are the first point of contact for the notification of disputes. Here are the steps in the Dispute Management Protocol. 1. Negotiation. Amicable settlement shall be made within 45 days. The following procedures under the parties' established Dispute Management Protocol. Upon failure of negotiation, the matter will be referred to the Dispute Resolution Administrator, or DRA, and the parties may proceed to file their request for mediation. The DRA makes a preliminary determination whether the matter is cognizable as a WESM dispute. If so, the mediation will proceed. 2. Mediation. A mediator will be selected and appointed from among those in the roster of WESM accredited mediators and arbitrators. Mediation will proceed within 30 days, unless extended by mutual agreement of the parties. 3. Arbitration. Parties will submit the request for arbitration and proceed to select the arbitrators based on the procedures under the DRMM. Once the arbitral tribunal is constituted, the DRA transmits the file to the tribunal and its secretariat, and the proceedings will continue as facilitated by the tribunal. Finally, the arbitral award is binding and enforceable among WESM participants, as provided under the DOE Department Circular. The said circular adopted the amendments to the DRM manual, stating that the parties shall bind themselves with the effect of submitting any dispute, controversy, or claim arising out of or relating to a WESM transaction to which they are or will be a party for settlement by arbitration. As to the effect to all other persons, the DOE circular states that all persons affected by an award of the arbitration panel shall comply with the award to the extent such award applies to them, notwithstanding that they were not parties to the dispute. The REM rules and the REM Dispute Resolution Manual provide for mechanisms and procedures to ensure speedy, efficient and cost-effective administration and resolution of REM disputes between and among REM participants and the Renewable Energy Registrar. REM disputes cognizable under the REM dispute resolution are those that involve the following. Attorney Jesucito Moralios served as the WESM DRA from 2011 to 2021. Now he is currently a member of the Rules Change Committee. While Attorney Teodoro Calao IV is the current WESM and REM DRA, as appointed by the PEM Board last November 2021. Here are the list of accomplishments and activities of the WESM Dispute Resolution Administrator. This now concludes our presentation. We hope you have learned something about the dispute resolution process that is valuable to your organization. Thank you for listening.